Welcome everyone. My name is Ayushi Jaiswal. I am an assistant professor, School of Legal Studies, BBT University, and this is a series of lecture on law of evidence. Law is classified into substantive law and procedural, or we can also call it as adjunctive law. It is said that substantive law is the law that confers power and rights or imposes duties and liabilities on persons, whereas procedural law deals with the procedure by which those rights, duties, and liabilities are enforced in court of law. The CPC, CRPC, Evidence Act, these are examples of procedural laws. And the first two codes lay down what court is to be approached for civil or criminal cases. The jurisdiction of the courts and the Evidence Act provides the methodology by which the cases have to be conducted in the manner of production of relevant oral, documentary, and other material evidences, and also the examination of witness. In Constitution, IPC, etc., are examples of substantive laws. Law of evidence is lex fori, which means law of the court, which is governed by the law of the country in which the proceedings are held rather than the law of the nation where the allegedly violated contract was created or the cause of action first accrued. We can understand this with the help of an example. Suppose an Indian Hindu marries an American Christian in Paris. They set up their matrimonial home in Geneva and later seeks divorce in Mexico. In this case, the Mexican court will have to first decide which law will be applicable to the cases to adjudicate on the issues of grounds of divorce. Let us assume that according to the Mexican law, the case has to be decided according to the law of the place where the parties have set up their matrimonial home. That is the Swiss law. It means that the Mexican court will apply the Swiss substantive law and decide whether the petitioner had the right to seek a divorce or not. But the courts will follow the Mexican law relating to their own jurisdiction and other procedures of the court in conducting the trial of the case. In other words, the Mexican court will apply its own procedural law as lex fori or the law of the court in matters concerning the procedure, but apply Swiss law in matters relating to the substantive rights of the parties. If in this case the husband has pleaded cruelty by the wife as a ground of divorce, the question whether cruelty is a ground of divorce will be decided by the court according to Swiss law. But whether, in fact, the husband has approached the correct court in Mexico for filing the case, and if he did, whether he would adduce proper proof of cruelty through witness and documents will be decided by the court according to Mexican procedural law as a leg fori. Thus, choice of the court will result in the choice of the lex fori with regard to the choice of procedural law. Before the introduction of Indian Evidence Act 1872, there was no complete or systematic enactment on the subject. Within the presidency towns of Calcutta, Bombay, and Madras, the court established by the Royal Charter followed the English rules of evidence. And outside presidency towns, the law was vague and indefinite as there was no fixed rules of evidence. It was the Bill on Evidence prepared by Mr. James Stephen in 1871 that was ultimately passed into the Indian Evidence Act 1872. The term evidence is derived from Latin word evident, which means to show clearly, or to discover, or to ascertain, or to prove. In simple terms, evidence refers to the proof of something that furnishes or something that furnishes proof. Though the Indian Evidence Act 1872 purports to consolidate, define, and amend the law of evidence, the Act does not exhaust the whole corpus of the rules of evidence. The purpose of Evidence Act is to make the probability of the existence or non-existence of any fact so high that everyone can believe its existence or non-existence. Indian Evidence Act contains 11 chapters and 167 sections. It came into force on 1st of September 1872 and recently on 25th of December 2023 the President of India gave the assent to repeal the Indian Evidence Act of 1872 with the new Bharatiya Sakshya Adhiniyam 2023. Now, regarding the applicability of the Evidence Act, the Indian Evidence Act 1872 applies to all judicial proceedings. The term proceedings is not defined in the Act, and there appear to be three tests for the determination of whether a proceeding is judicial or not. The first test being the objective test. An inquiry is judicial if the object is to do is to determine a judicial relation between one person and another, or a group of persons, or between him or the community generally. But even a judge, if not acting with such an object in view, is not acting judicially. Here, judicial means related to law or to legal rights and obligations. The second function being the functional test. Section 2, Clause 1 of CRPC defines judicial proceedings as proceedings which include any proceeding in the course of which evidence is or may be legally taken on oath. In a case, it was held that all men are mortals, but all mortals are not men. A judicial proceeding may be one in which evidence is or may be legally taken on oath, but all proceedings in which evidence is taken on oath do not necessarily mean judicial proceedings. Here, the test is whether the body conducting the proceeding is authorized by law to receive evidence and decide on the basis of that evidence. The last test being the approach or process test. Here, another a very important test is that is invariably applied is whether the decision making process involved the application of a judicial minor judicial discretion, which is guided by the evidence adduced by both the parties. This test distinguishes the judicial proceedings from a proceeding or an inquiry conducted by an administrative body, where the final outcome depends on the fact discovered by the body, which is not clothed with any discretion. Fact finding and inquiry commissions come under this category. It must be remembered that just because a legislative enactment provides that a body shall be deemed to be a court for the purposes of summoning documents and following the principles of natural justice, like giving notice to and hearing both the parties, it does not make its proceedings judicial. Those proceedings, in spite of having certain trappings of a court, are not strictly judicial proceedings. A proceedings may be quasi-judicial proceeding, without being strictly a judicial proceedings. It is obviously that all the above three tests are to be applied cumulatively in the determination of the nature of proceedings as judicial or not. Consequently, departmental proceedings against employees in disciplinary matters, etc., are not judicial proceedings. Also, the position of commissions of inquiry is also the same. On the other hand, some of the proceedings related to election offences under the Representation of People Act are of a quasi judicial nature, and the provisions of the Evidence Act are applicable to the proceedings under the Act, and they are considered as a judicial proceedings. And the question arises whether Evidence Act is applicable on arbitration proceedings or not. So, Section 1 of the Indian Evidence Act clearly provides that the Act does not apply to proceedings before an arbitrator, and it does not make any distinction between the statutory arbitrations under Section 10 of the Industrial Disputes Act or private arbitration and the Arbitration and Conciliation Act. The Arbitration and Conciliation Act 1996 repealed the old Arbitration Act of 1940 and provides that the arbitral tribunal constituted under the Act shall not be bound by the CPC or the Indian Evidence Act. Under Clause 2, the parties are free to agree on the procedure to be followed by the tribunal, and failing that the agreement, the tribunal may conduct the proceeding in the manner it considers appropriate. The power of the arbitral tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. It is significant that the Act gives total autonomy to the parties with respect to and does not even require the procedure agreed to by the parties or laid down by the arbitrator shall comprise the principles of natural justice. Also, Section 1 of the Evidence Act states that The act shall apply to court martial other than court martial convened under Army Act, Naval Discipline Act, Indian Navy Act, or Air Force Act. The question arises whether Evidence Act is applicable on affidavits or not. So, what is an affidavit? An affidavit is a sworn statement made by a person as to the truth of the facts within his knowledge mentioned therein. Order 19 of CPC and Section 297 of CRPC regulate the operations of affidavit. Order 18 Rule 4 of CPC requires that in every case examination in chief shall be given by affidavit, and the cross and re-examination shall be by oral evidence recorded by the commissioner appointed for that purpose. Section 3 of Indian Evidence Act provides that oral evidence is defined as statement made by witness in the court of law, and as affidavits are not statements made by witness in the court of law, affidavits were held to be not evidence. Section 1 of Evidence Act expressly excludes the affidavits from the purview and provides that Act does not extend to affidavits presented to any court. So this was all on this topic for today. Thank you very much. See you in next topic.